The State of Crypto is presented by Tron, connecting the world to the power of cryptocurrency.
All right, the creator of the animated web series Stoner Cats has agreed to pay the SEC a $1 million civil fine to settle charges that it conducted an unregistered securities offering. Stoner Cats has not admitted or denied any wrongdoing in settling the charges. This comes 2 weeks after the SEC brought its first enforcement action against an NFT project. Joining us now to discuss the legal implications here is managing partner at Leichtman Law, David Leichtman. Welcome to the show this morning, David.
Good morning.
All right. So the second NFT enforcement action here, 2 weeks apart. Is this the beginning of more actions to come? Should NFT projects be worried here?
I think it may be. I also think it's part of reviewing these various settlement orders, which is a heavily negotiated document, but largely written by the SEC staff, are meant to give some amount of guidance to people in the future who are making these kinds of offerings.
Now, there are so many NFT projects out there, David. We have these two, Impact Theory, Stoner Cats, both have noteworthy people behind them. Why do you think that the SEC chose to go after these two specific projects first?
Well, I think one of the main points here is that the folks involved in both of these two early enforcement actions had the means and wherewithal to hire sophisticated securities counsel in order to file the proper registration statements. Whereas if you're some kind of individual artist or a small rock band or something like that, you might have an arts and entertainment lawyer, but you don't necessarily know that you need a securities lawyer, and your arts and entertainment lawyer, it may not even occur to them. So I think, what they're doing is they're going after, in order to lay down, for the future what the rules are going to be that everybody will know about. They're laying out some rules with some folks that probably should have been able to consult with counsel.
So speaking of those smaller artists, the musicians and designers, et cetera, what does this all mean for them? If I'm just a guy who's making a few JPEGs and trying to sell them to pay my rent, or I have a small band and I want to, I'm playing a gig at the local clam broth lounge on Saturday night, and this is the best I can do for extra money. Does this mean I'm a securities dealer now?
Probably not. When you look at the facts that are laid out in the SEC's settlement order, what you see is a whole host of facts indicating the degree of control and sort of promotion that the sponsors of these NFTs were engaged in. And I think the ordinary person or small artist or artist group is not going to be involved in all of the various aspects of that.
Something that was noteworthy with this and happened with the Impact Theory case we learned about 2 weeks ago was that two commissioners, Hester Peirce and Mark Ueda, issued a dissent. What did you make of these? Now 100% of NFT enforcement actions, albeit it's just two right now, have almost half of the commissioners issuing a dissent to say that they don't necessarily agree with what's going on here. What do you make of this?
Well, they were, essentially making the same point that Lawrence was just making, which is, there might be a degree of unfairness here to, individual artists and creators of all types, which, I think is, a good point. But again, what I think they're trying to do is, and they've been doing this really since 2017 when they issued an initial report and some regulations and then in 2019 some guidance. They're trying to lay down the rules of the road, and there ought to be at some point a very simple kind of registration statement that you can file, because what they're most interested in is not shutting down the NFT markets or even slowing down the ability to issue and trade NFTs, but what they're trying to do is create an environment where there is sufficient disclosure for investors to understand the risks, which I think are not very well understood. Now, in their example, the dissenting commissioners gave an example about Star Wars toy figures, which it was a good effort to make an analogy, but I think it's not a perfect analogy here, because in that circumstance, right, Lucasfilms is actually the creator of the films and the characters. They may license the toy company, but it's really the toy company selling the collectibles, and not the creator of the work controlling that market. And then in the aftermarket, the secondary market for collectibles and things like that, there's no resale royalty, and there's no compensation that goes back to the original creator, Lucasfilms. So it's not really a perfect analogy. There might have been some other analogies that that could have been further thought through, but they're certainly sounding the alarm that people need to pay attention to this, including smaller entities.
So what are the specifics that make the difference? I mean, you mentioned a little bit about the promotion aspect that Stoner Cats had, the cartoons, et cetera, the online and TV presence. But what exactly is it that distinguishes then Stoner Cats from your stone friend who's making an album?
From the other kind of Stoner Cats.
Yes. Well, I think there were a couple of things, a lot of different factors that go into this analysis under a test enunciated by the Supreme Court in 1946 in a case called Howey. And basically, in this circumstance, I think there were a few things that troubled the SEC. One was there was no limit on the number of NFTs you could buy in this series, and you only needed one to actually consume the content that you were getting access to. And so, if you think about it this way, people are therefore just only really buying the additional, NFTs for the purpose of making some kind of investment gain, for which they're relying upon the initiator of the NFT series to promote and put out content in the future, as opposed to just buying something tangible in the past. So I think that was one aspect about it that the SEC in particular was concerned about.
All right. And David, before we go, we want to play this clip. Actress Mila Kunis actually spoke to CoinDesk TV about the project. Back in 2021, Kunis' production company, Orchard Farm Productions, backed the cartoon series. Let's take a listen.
Stoner Cats was a concept of a show that we wanted to put out on, streaming or television broadcast and otherwise. And we were doing this during quarantine, during COVID, and it became a really oversaturated market, the market of animation. And I was like, how do we stand out? How do we do something different? And how do we not have to comply with, rules and regulations when it comes to our show? We want it to be very loud and very specific and very honest and true to its nature. And Mario works with Ashton, and they kept talking about these things called NFTs. And I know I sound like a crazy person, but I was like, what is an NFT? So this is 2 years ago. I was like, what's an NFT? And so then I got a beautiful explanation as to what NFTs were. And I was like, wow, this doesn't make any sense. So cut to COVID happens, Stoner Cats. And I was like, I wonder if I can make this into an NFT. So Maria lovingly was like, let me help you out. And helped, take this little train and truck it along in the world of tech and crypto and all the things that I knew nothing about.
All right, Mila said there, how do we not comply with rules and regulations, albeit I think she's referring to broadcast rules and regulations because it is a little bit of a crass show. How would you advise creators who want to do the same thing, who are thinking about NFTs, who are maybe a step above Lawrence's example there? Should they do that? Should they be out there getting a securities lawyer and registering with the SEC?
Again, I think it depends. You certainly should be getting advice from counsel who are familiar both with securities laws and intellectual property laws. And, one of the sort of ironies of this is that, in the ordinary art world, we don't have resale royalties, right? When there's a sale on the secondary market. And, part of what is attractive for NFTs for creators is the ability to obtain resale royalties from the way smart contracts work. And so resale royalties are wonderful, but the more control that you exercise over future sales and the more that you involve yourself in promotion and marketing of what you are suggesting to the purchasers, the benefits will be of investing in it as opposed to just trying to get your content out there, then the closer to that line you're going to be.
All right, David, we really got to go, but do you have a ballpark figure on what it would cost a creator to register an NFT as a security?
Well, again, I think right now it's probably pretty expensive to hire the right lawyers. And, because the SEC is still finding its way here, it may, take some time when you submit the registration statement for the SEC to approve it. But I think as time goes on and hopefully, rapidly, there will develop forms, that can be used, so you don't have to hire the biggest white shoe, law firm in New York City or Los Angeles, and, other, sort of less expensive, counsel can assist you. I don't think we'll get to a point where you can do it yourself. But maybe there will be law school clinics and things like that might arise that can help, that can help with this process. But I think we're at the beginning stages of this. And so right now it's going to be pretty expensive.
David, thanks so much for joining us and unpacking that for us.
Thank you.
That was managing partner at Leichtman Law, David Leichtman.